Hi everyone, and welcome to our webinar on the new annualised salary provisions in modern awards that will be coming in on the 1st of March this year, 2020. We thought the best way to give you an update would be to record a really brief webinar that provides you with all the information that you need to know to be compliant in a concise and efficient way. So today we're going to go through a few different things. Look at the background. So what is an annualized salary? We're going to have a look at the impacted awards and the new requirements from the 1st of March this year. We're going to review the 3 model clauses, how they differ and how they apply, and then practically what you need to do to ensure you're compliant. As we know, there's been a lot of talk around the annualised salary provisions, and it's important that you prepare your organisation to make sure that you have everything in place ready for the 1st of March. So let's begin by having a look at what is an annualised salary. So in some modern awards, there's a provision that's referred to as an annualised salary. And what that is, it allows you as an employer to pay an employee an annual salary that's inclusive of a number of minimum entitlements. So instead of the employee getting a minimum wage and then being paid any penalty rates or overtime as it occurs, they get paid the same weekly wage or the same annual salary. So normally an annual salary will incorporate minimum wages, penalty rates, monetary allowances, overtime and annual leave loading. Annualised salary provisions are only included in some modern awards, and we're going to have a look at what awards that is shortly. And often the terms of an annualised salary differ from award to award. So in some modern awards currently, if you want to offer an annualised salary, you need the employee to agree to it. In others, it can just be dictated as the terms and agreement to the employee. So annualised salaries have really been attractive to employers previously because it allows them to forecast their wage cost accurately. So you know, okay, for the next 12 months, if we continue with this headcount, the annual cost is going to be this much. It also eases the administration of having to determine the employee's rate of pay each week based on time worked. For employees, annualised salaries have offered a number of benefits. It allows them to know what they'll be paid each week and therefore support with income security and know that their pay is not going to go up and down dependent upon the overtime hours worked, penalties, etc. So annualised salaries are very common. A lot of organisations offer them, a lot of organisations have them in place for those specific reasons. However, with the new complexities coming in on the 1st of March, we have many clients assessing whether they want to continue with annualised salary provisions because there are additional requirements that are being put in place. So let's have a look initially at what awards currently contain annualised salary provisions. So there's currently 19 awards. Each of those are listed on the screen. The Fair Work Commission has recently undertaken a 4-yearly review of modern awards, which has resulted in annualised salary provisions being extended to 2 new awards. So I've mentioned those at the bottom of the screen. There will also be an extension to the Health Professionals Award, but the commencement date for that has been deferred. So we will provide further information if that impacts you when that comes up. So if you're covered by one of those awards and you have employees covered by one of those awards under an annualised salary agreement, it's really important that you're across this information. I'm going to go into detail now around what the new requirements are from the 1st of March this year. So the first requirement is you need to ensure that the annualised salary that you pay the employee must be sufficient to cover what entitlements the employee would receive if they were paid under the award. So you need to make sure if they were paid minimum wages, penalty rates, overtime, that the annual salary is in excess or equal to what they would be paid if they got paid an hourly rate with those entitlements. The annualised salary must now be recorded in writing and it must clearly outline the method for calculating the annual salary. So what provisions are incorporated into the annual salary and how they were determined. For the Restaurant Award, the Hospitality Award for non-managerial staff, and the Marine Award, you must apply the percentage specified in the award. So those 3 awards are treated a little bit differently, and they actually have, if you apply this percentage, then you are compliant in that particular area. Additional requirement is you must specify in writing the outer limits for overtime and penalty rates. So for example, you may say employee named Jane, when we calculated her annualized salary, we calculated that she will do a maximum of 5 hours per week overtime in addition to her standard 38 hours per week. The agreement or the annualised salary must not disadvantage the employee. There's also a requirement for the employee's hours of work to be recorded, so that's their start time, their finish time, and any unpaid breaks they take during that time. Each pay period, if the outer limits you have set have been exceeded, then you must pay the difference to the employee. So if we go back to our example before, we look at Jane. She works 38 hours per week. You set an overtime limit at 5 hours per week. For some reason for that week, Jane works 10 hours. You must pay her that additional 5 hours at overtime rates under the award each pay period, or for that particular pay period. In addition to that, there's now a requirement every 12 months for you to conduct an annual reconciliation to determine if there's been any underpayment and pay the employee the difference. So some really detailed new requirements that haven't previously been in place before, and an obligation on the employer to keep records to show that they're compliant with each of those. So what we'll do now is we'll go into a little bit more detail and have a look at the model clauses, or some background around the model clauses. There was initially going to be 4 model clauses. Model clause 2 is no longer going ahead, so there'll actually be 3 clauses that will be implemented to each of the awards. So if we have a look first, we're going to have a look at Model Clause 1. So Model Clause 1 is going to be inserted into awards that already contain annualised wage provisions, but do not require employee agreement, and it covers industries and occupations that have relatively stable hours of work. So this clause will go into what is defined as Category 1 awards. So I've listed the Category 1 awards there. With these awards, if you pay an annualised salary or you're offering an annualised salary under any of these awards, you don't actually need employee agreement to do so. Let's have a look now at Model Clause 3, remembering that Model Clause 2 is no longer going ahead. That's why it looks like we've skipped one. So Model Clause 3 will be inserted into awards that already contain annualised wage provisions, and they cover employees working highly variable hours or ordinary hours, and the majority which attracts penalty rates. So your Category 2 awards are listed there. You'll note that I've put 2 awards at the bottom there that didn't previously contain annualised salary provisions, so they will actually be new provisions in each of those awards. With Model Clause 3, employee agreement is needed in writing to be paid an annualised salary. The agreement can be terminated with 12 months' notice or upon mutual agreement between the employer and the employee. Lastly, let's have a look at Model Clause 4. So Model Clause 4 is for the following awards only. It's actually not going to commence on 1 March 2020, so we'll have further information about that shortly, but it will fall under the Restaurant Award, the Hospitality Award, and the Marine Award. So for Model Clause 4, employee agreement is needed in writing. As with Model Clause 3, it can be terminated with 12 months' notice or upon mutual agreement. So if we have a look at this, that's a lot of theoretical information or background information around annualised salaries and what you need to do. Practically, as an employer, what do you need to do to ensure that you're compliant? I've put together a number of steps that you can follow to be able to make sure you've set your organisation up so that you're compliant with the new annualised salary provisions from the 1st of March. Let's have a look at those. So steps to determine the annual salary for Model Clause 1 and 3. You then have the obligation to monitor the annual salary. So what you need to do is you actually need to keep a record of an employee's start times, finish times, and breaks. So this is a key requirement. The employee needs to acknowledge their hours of work, so whether that be an electronic acknowledgement online or signed by the employee, they need to record their hours of work. This is going to be a substantial change for many employers who don't have employees clocking in, clocking out, or any way to record their hours of work. In order to comply with this obligation, you're going to need to put something in place. Secondly, you need to check each pay period if the identified outer limits for overtime or penalty rates have been exceeded. So let's say we go back to employee Jane. You've said that the maximum hours of overtime that she will work is 5 hours per week. Then 1 week she works 10 hours. Then it has been exceeded by 5 hours, and for that pay period she would then be paid 5 hours at overtime rates. You can't actually average this out, and that's probably a question that we've been getting a lot. So, because the requirement in there is for you to actually make a payment outside the outer limits each pay period, let's say, for example, Jane only did 2 hours overtime in week one and then did 8 hours in week two, many employers would say, well, over those 2 weeks, she's only done the 5 hours. It actually states that anything outside the outer limits need to be looked at on a pay period by pay period basis. In addition to that, the final obligation for you as an employer is to conduct an annual reconciliation every 12 months or upon termination, comparing what the employee would have been paid under the award to what they were paid under the annualised salary provision. If there's been any underpayment, you need to rectify it at that point and pay it to the employee. So, all of these additional obligations are really making employers reflect on their decisions to utilise annualised salary provisions, and a number of the benefits that they received previously around reducing complexity have been replaced by these new obligations. So, our suggestion is for you to undertake each of those steps for any of your employees in your business currently covered by an award under an annualised salary provision. Be really careful not to just state, oh, we just pay a salary and awards don't apply to us. If the coverage clause of a modern award covers the work your employee performs, then that award is applicable and you are paying an annualised salary. Any employees on an annualised salary covered by one of the awards we've discussed today and you need help to implement the changes, please get in touch with us. Details are on the screen, so you can reach us via 1300 887 458 or send us through an email to inquiries@liquidhr.com.au. Thanks very much. Bye.